No, I think it's
Our next speaker is Dr. Silva, who's a partner with CMS legal firm. His presentation it would be around IT professional things IT professional needs to know about GDPR and the contracts. I'm not quite sure what contracts, but contracts with, I leave it to Sam to explore this. It's going to be quite interesting. It concerns most of us, or some of us, so clearly it concerns me. So let's listen to Sam's presentation. It's 45 minutes. We've got 15 minutes questions, but if you go over 45 minutes, and if you're happy to take questions in the middle of the presentation. Yeah. Unfortunately, we don't have a microphone, so you need to shout. Sorry. Thank you very much, and I'll hand it over to you.
Good morning, everybody. It's still morning. So as Reza said, I'm going to talk about one area which I don't think's been addressed very much. We've all heard about, data subject rights, privacy policies, rights to be forgotten, deeper data protection, impact assessments. But I think the area of contracts hasn't really been addressed. So what I mean by contracts is basically this is where your organisation, either where usually when you're a customer, you either outsource or you procure an IT system or outsource it to a third party, and that third party processes personal data on your behalf. What do you need to put into that contract to be GDPR compliant? Is that surprising? People know that you need to put specific clauses in rather than just say the service provider shall be GDPR compliant, because that's not going to work. So what am I going to talk about? So I'm going to set the scene, going to talk about what needs to change in the contracts, and then the process in terms of getting them GDPR compliant, i.e. identifying and triaging relevant contracts. Your organisation is going to have hundreds of these contracts. With only 42 days to go, you're not going to get through all of them. Hopefully you've started the process. I'm not going to ask the question because I don't want to embarrass anyone. So hopefully you have started the process of getting your contracts GDPR compliant. Talk about some of the risks with potential approaches, key issues when you're negotiating with suppliers, and then sort of looking forward, what are the things you need to consider. So with only 42 days to go for GDPR, contractual compliance is likely to be one area which you probably should have started. And why I say it should have been started is it's not within your control. You need to negotiate this with a third party. So, it's not like you can all do it yourself. You need to enter into a dialogue. So that's why these things take time, and hopefully you have started. So what you should have done is, identify your suppliers and customers. You need to triage the data protection risk. You need to determine which approach you're going to take, and then you need to negotiate, draft, and make changes to the contract. What we've seen in the last 18 months is that the contractual market has changed considerably. So probably about 18 months ago, the contract clauses were probably about 10, 15, 20 pages. Now what we've seen is that it's become shorter, only 10 pages as opposed to 20 pages, but they're moving away from the prescriptive requirements, and I'll talk about the prescriptive requirements of the GDPR. The GDPR says, you need to have these clauses in a contract. So they're moving away from them and actually looking at the factual matrix and looking at what the actual parties do. So it's a more what actually happens in practice rather than actually looking at the actual GDPR and saying, well, you're just putting these clauses in there. So question is, what contracts need to be sort of updated? So as you know, most of the data processing contracts will need to be updated, or you risk a fine. But this is really a tier 2 fine, so it's not as scary. It's only 10 million euros, or only 2% of global turnover, as opposed to 4% and 20 million euros. So tier 2 fine, but still fairly significant. So what is a processing contract? So effectively, it's any contract which includes a component of or relates to the processing of personal data, where the counterparty, i.e. the supplier, has access to personal data of your customers, employees, contractors, suppliers. So the assumption you should make is most contracts you have will be a third-party processing contract. But you may want to take a risk-based approach, because you're not going to have time to go through all the contracts and to remediate them. The definition of processing, as you know, is quite wide. It's quite wide under current law. It's even sort of probably more wider under the GDPR. So, for example, it captures. So what does it capture? It captures storing of data. That will include personal data, for example, use of third-party cloud service providers. So potential access to data. So even if the service provider doesn't actually access or do anything of the data, even though they may have the actual technical means to actually do it, they will be processing the data, even though they don't actually do it. So the types of contracts and clauses you need will depend on whether the third party is actually a data controller or a data processor or a joint data controller. So this is really, the determination is really a question of fact. So there's no point appointing a service provider and saying you're a data processor or you're a data controller or you're a joint data controller. It's actually the question of fact. So regardless of what the contract says, you need to know what they're actually doing, and that will determine what category they fall into. So just as a summary, data controller, that is a party which exercises control over the processing of personal data. Data processor is one which sort of processes personal data on behalf of instructions from the data controller, and a joint data controller is where both parties together determine the purposes for which the personal data is being processed. So in terms of sort of looking at sort of updating the contract, so we'll look at the scenario joint controllers. So this is where they jointly determine the purposes. So the Article 26 of the GDPR says that the sort of allocation of responsibility needs to be set out fairly clearly, and it also needs to make sure that the data subjects knows who they actually need to go to in terms of making a data subject access request if they're both a data controller. So what we would recommend is that if there is a joint data controller arrangement, you actually set out in the contract who has responsibility for what. For example, which party has responsibility for direct contact with the data subjects? Would you want to restrict the other party having sort of access or contacting data subjects and so forth? So what we're saying, best practice, what we've seen is effectively a sort of a data subject sort of facing statement or notice, which sets out the essence of the role, so which sets out basically what each sort of data controller is responsible for. And clearly going forward, you need to have a process that sort of maps out what you actually said to the data subject. So that is a scenario which, it is like probably not a common scenario, but there are situations where you both will be joint controllers. The most likely scenario is where it is a controller to processor contract. So this, basically under the GDPR, a controller can't appoint a processor unless it provides sort of sufficient guarantees that the processor has adequate organisational and technical measures in order to protect the data, and that's Article 28.1. So this means there's an obligation on the processor, the organisation who's looking to appoint the IT service provider, to carry out a due diligence on the service provider, and that due diligence actually extends beyond the point of contracting. So it's not all about at the point of contracting or prior to contracting, you do the due diligence. You need to continually ensure that you monitor that. If the service provider complies with an approved code of conduct, and there aren't any approved code of conduct at the moment, but there is likely to be. Pity that the ICO gentleman isn't in the room, could have asked him that question. But if the service provider complies with a code of conduct, you are in the room, sorry. Yeah, exactly, yeah. I see you moved from the front to the back.
That's the idea.
Yeah, okay. So, just in terms of code of conduct, where are we?
Yes. Oh. Can I have a think about that?
Yeah, that's fine, yeah.
I'll have a proper think, Sam, answer fully.
Yeah, that's fine. So when the data controller engages the data processor to process personal data on its behalf, it needs to do so under a written contract, and that hasn't changed under law. It's a current requirement under data protection law. But under current data protection law, there's only sort of a few protections that are actually required to be put into the contract. So under current law, what are the things that you need to make sure that you put into the contract with a data processor under current law? Do you think you need to put anything into your contract? How many of you think you need a contract? Oh, that's good. Okay. So what do you need under current law? What do you need to put into the contract?
Rights of access to, in case there's a breach.
No.
Well, it's not compulsory, but I would put that in.
Yeah, no. I'm saying under current law, what is compulsory?
Well, there's nothing because that will come in under the.
No, there is. Under current law,
Well, that the data is processed in accordance with the data protection principles.
Well, accordance to instructions. That's one. What's the other one?
Identity of data controller and data processor.
No. So the two things under current law that under Data Protection Act, which you need to put in, is that the processor processes personal data in accordance with the controller's instructions. One, and the service provider must have appropriate technical and organisational measures. So those are the two things that are under current law that you need to be put into the contract. The other misconception under current law is what's wrong with a contract under current law which says the data processor should comply with the Data Protection Act. What's wrong with that?
You do anyway, I'm sure.
No, they don't have any obligations under Data Protection Act. Nothing. That's the game changer here. Under the GDPR, they will have direct obligations under law. So all your existing contracts, if you've got that clause in there, it's meaningless. So you're pretty fortunate that you haven't had a data breach and the ICO regulator hasn't actually come in and said, oh, okay, that's an interesting clause. There's no point in it, but, interesting that you have it. So that's the current state of play. So under the new...
Are we allowed to interrupt first?
Yes, of course.
Right. There's one other very significant player in all this. So you've got processors, controllers, but you've also got people like developers who aren't involved in the day-to-day operations, but do at some point in the life cycle have access to all the information. What should you do about developers?
There'll be a processor.
So they're counted as a processor
Correct.
in exactly the same way?
Yeah.
Sorry, just on that point.
Yeah.
The significance, surely, currently, if you have a clause as such, isn't so much under the whether or not you've complied with data protection, that there's a contractual right to sue if they don't do it in that way.
Well,
Protecting the data controller.
no, if you had a clause that the data processor shall comply with Data Protection Act.
Oh, not that particular
No.
clause, but other clauses.
Yeah, other clause,
normally in at the moment.
Yeah.
Because obviously that is meaningless, as you say.
Yeah.
As it stands. at the
Yeah,
moment.
so that's why clauses like they should not sort of transfer data without your consent, they need to put appropriate technical organisers, that you'll have a contractual right, yeah. So that's the current state of play. Under the new GDPR, that includes a raft of additional provisions that need to be included in the contract. And some of these, you need to set out in detail what the processing is in terms of the subject matter, duration, nature, type of personal data, and the categories of data subjects. So that's quite a detailed schedule that you need to include. You need to obligation that the data processor should ensure that only personnel authorised to process personal data have committed themselves to confidentiality. there's an obligation on the processor that they need to assist the controller with data subject rights, security measures, data breach notification, impact assessments where relevant. The data processor needs to make available to the controller all information needed to demonstrate compliance. Processor needs to allow and contribute to audits, inform the controller in its opinion if the instruction infringes the GDPR or any other data privacy law. So those are things that the GDPR says you must have in your contracts with data processors. And if you don't, you'll be in breach of the GDPR. So, you know, hopefully you've started that process. You may think, well, I'm just an IT professional, IT director, CISO, that's not really my responsibility. Sorry, I get to you. Yeah.
Irrespective of the contracts, under the Data Protection Act or Bill and the GDPR, the processors can be approached directly by the regulator anyway, can't they?
Correct.
So even if your contract is incorrect, the liability still potentially sits on the processor.
No, it sits with you, the controller.
No, but it sits with both, doesn't it?
No, but primarily it sits with the controller. You'll still be in breach.
Yeah, no, I know you will, but they will too.
Well, they've got less obligations. So if
still the processor again, aren't they?
yeah, but if the breach was to do with something that they did, they potentially may be liable. But
That's what I meant,
yeah, but still, you'll be that's not. I don't think this.
From a negotiating position.
Yeah.
Their position is not that they have no liability at all at the moment.
Sorry.
Because as soon as the law changes
Yeah.
or is updated,
Yeah.
they are to some degree at risk anyway, because they can't contract out of their legal rights.
Yeah, but just having their obligations are quite limited under law.
Okay.
Yeah. So sorry, is your sort of angle from a service provider perspective or a customer perspective? I'm just interested to see what.
Customer.
Yeah. So their argument to say, well, we have, their argument if they say they don't want to agree to these, you go, well, too bad, you have to. There shouldn't be any you shouldn't be dealing with any service provider saying they don't want to accept these clauses.
The pushback you often get is our standard terms of this, and this is just how it is.
No, because the standard terms, if they don't comply with GDPR, they could be potentially in breach of that.
Exactly.
Yeah. But it's interesting because the guidance doesn't the GDPR doesn't actually say who's actually responsible for putting those clauses in. So there's a strong argument to say that it's a controller. So that's why lots of service providers are just sort of remaining quiet and hoping that their customers don't approach them. So how many of you are actual service provider companies? And how many of you presented your data processing clauses to your customers?
We're going through the processes at the moment. One of the biggest issues that we're encountering is that our clients, and they're probably small compared to a lot of you guys here, but we're talking small and medium organisations with 300-400 users in them. Some of them haven't actually got their head around yet who their data controller is. It's as fundamental as that, which is crazy. But by and large, our process is actually storing their backup data in our data centres.
Yeah.
So obviously we have a responsibility, we have their data, but they can't yet identify to us actually what they've got as part and parcel of that backup data. So we're kind of pushing the back to them a little bit and kind of saying, hey guys, we can only deal with what we're given. We can't obviously stop doing backups for people, that's nuts. But it creates some other issues and problems.
Yeah.
It must be said.
Well, I think what you need to present is, it's in your interest to have these clauses. You'll be in breach of GDPR, not us.
Yeah, and our understanding is that if we suffer a breach, which God forbid that we do with all our ISOs and God knows what else, but it's not impossible, that actually it's the data controller for our client that's the one that cops it. That's what we've been advised.
Well, no, if you're at fault...
That may not be the case, we'll still be negligent, but
Well, no, it depends on who... If the breach was because of something you did, you'll be responsible. They'll be responsible because they haven't got the clauses in. But if it was nothing to do with you, and the breach happened for some other reason, then obviously it's just normal common sense, really, yeah. You were a service provider?
No, I'm a customer. I want to throw in just a slight contrast to this conversation, a really prosaic example that we have. Because we're all sitting in this room thinking about IT service providers, SaaS providers, all the rest of it, where all of this makes sense. It's part of the normal contractual dialogue. One of the things my company does is we run CPD events, and we regularly have very short-lived contracts with venues, transportation companies, all the rest of it, many of whom require from us personal data about delegates.
Yeah.
And all of those companies, they've never heard of the stuff like that, and we're going, well, hang on, can we actually use this hotel for a venue, because they're not telling us how they're going to protect the delegate data we're giving us. So it's what I'm saying is, there are those sorts of things which are very high volume, but probably very low risk, are going to be the areas where this is going to be quite a tricky subject, I think.
Well, it's not tricky in the sense that technically you still need to make sure you've got the right clauses, yeah.
Well, I just throw it in as an interesting contrast to the big IT contracts that we all think about as our day job.
Yeah, but just because it's short term, if they have a huge volume of data, that makes it high risk.
Yeah, yeah.
So it's not just about the short term nature.
Yeah, I was going to say, we're a data processor, but for far more than backup data, we've got media hosted platform stuff for customers. The thing that surprised me so far is that none of our customers, being small and fairly mid-sized and some big resellers, none of them have actually approached us about changes in terms that they're asking for as data controllers. So we're a data processor, but nobody's yet contacted us.
I'm not surprised. I mean, yeah, as I said, this hasn't been an area which people have thought about, but you know, it's not a sexy area. You know, no one really thinks about this, but you know,
we've got a slightly different, again, as a service provider. So we've been reasonably proactive about it and looked at the various contracts we've got and said we need to be talking about this. The challenge for us is we'd love to have a standard approach, but each of our clients has a massive bespoke contract with a completely different view on it. So the amount of work that we're having to do to try and get each of these in place is enormous. And then we have some other issues where we've got legacy contracts, where, really interested in your point, if these contracts don't have those clauses in, we get past May the 25th, and we've still got this legacy contract which hasn't been novated or varied in any way. Who's on the hook for not having those clauses in? Both of us.
Yeah. Well, for instance, as I said, it's unclear under the GDPR, and ICO, sorry, I know your guidance is really helpful. You haven't given any guidance on this topic. Is who is responsible if you haven't got those contract clauses? Because it's not clear.
Sorry, can I just suggest something? I think one of the problems is it's a bit unfair for data controllers and processors to just think about it in isolation. I mean, it's a legal issue, so if you're a large...
so you're going to blame the lawyers there?
No, I'm a lawyer, so why would I? But the point I'm making is, if you're an organisation, the whole idea is that data protection is a responsibility of the whole organisation, as has been emphasised by the ICO. So it comes from the board. This stuff should be on the risk management from board downwards. Get all our contracts out and get them checked out by lawyers. That's the simple approach to solving that problem. It shouldn't be for the individual people it should come from board level right down, if it's an organisation that's got a board. I mean, the problem is obviously for smaller organisations, but a larger organisation, even a charity, which is effectively got a board, should have dealt with this at a board level down. So,
no, I agree, but that's the ideal situation. You
but
know,
they want to be because that's always been, even on the DPA in 1998, it's not rocket science.
Sam, can I ask you a quick question?
Yeah.
So how many organisations have you seen, so this would be processors, so in this context kind of service providers, put in kind of like either an addendum or a data processing agreement? Because your point around staying quiet, something we did, I'll come on to what we do. But what we've done is have this default data processing agreement that kind of appends the gentleman's idea of a contract, putting those together and saying these are our clauses. If you are mature enough that you've actually gone down the route of assessing what you as a controller want, we can potentially change these. But if you've done nothing, we're kind of ask covering and saying this is our DPA, sign this. And that gives us basically evidence that we're looking at and a common set of controls. Are you seeing lots of people do that?
It's a mixture, either addendums or new agreements and stuff. The issue common issue I've seen is vendor clients are just assuming that if they send these DPAs out, and even if they're not signed, it's just assumed to be accepted. You can't do that. There's no deemed accepted. You need to actually get that signed. Yeah. So in terms of other things that you need to do is that if you can't, the processor can't engage a subcontractor without sort of price-specific consent of the controller. So if you do actually need to do that, you need to make sure that the contract between the processor and the sub-processor actually sets out the sort of the back-to-back sort of provisions in there. This is, I mean, best practice is trying to get the consent before, trying to get the service provider or the processor to get consent before they actually do it, but that can be practically quite difficult. So lots of vendors are pushing back on it, and some customers are accepting that, you know, they've sort of got a general consent to do this. I think that's quite a dangerous proposition. It's basically a risk-based exercise. But even if you do give a sort of general consent, you need to make sure that at least there's a process in place that the processor actually notifies you. So they don't actually you actually concede at that point that, you know, you don't need the consent before they do it, but they actually notify you of who the actual processor is. Even though that the processor appoints a sub-processor, the processor should still remain liable for the actual emissions of the processor. They can't sort of delegate that responsibility completely. So in terms of the process of how you're doing it, so the first step to sort of revising your contracts to be GDPR compliant is to determine what contracts you actually have in place. So you need to do a bit of due diligence and data mapping. So in terms of the actual due diligence, you know, what are the sort of what are the sort of IT sort of contracts, IT solutions you have? You know, what are the sort of different functions and jurisdictions that your business operates in, so you can make sure that all the sort of systems and contracts are covered there. So at this stage, it is basically your aim is to identify all the contracts. So it's just basically the due diligence exercise. But the second stage is actually determine what you're doing with all those contracts, but you at least need to know what all your contracts are. So a way what we've seen is how this could be done is actually having a due diligence questionnaire which is issued out to the business, which asks a variety of questions and identifying sort of red flags and stuff. And, you know, lots of consultant law firms have developed questionnaires and so forth. You know, you can obviously pay for that and develop your own or whatever, but that is a useful way to get the information. Once you've got the responses from your internal teams, you can sort of compile sort of data maps and see where the data is being transferred and so forth. And that is a valuable tool in determining which contracts are really high risk and in terms of what you need to actually do with this. I think one sort of step which is often missed is basically the education piece. So just issuing out a questionnaire is not going to be that helpful. You need to educate the people. What are you trying to achieve here? You know, what is the purpose of them actually completing this questionnaire? So it's all about education. And you want to ensure that you receive good quality feedback. The worst thing is you send out all these questionnaires and you get half-baked responses or things that just don't make sense. You know, that's not going to help anyone. So you need to educate to make sure that what you receive back is actually useful. Let's skip ahead. So you've engaged with all the internal functions in business, and you know what your potential key suppliers and customers are. You have a comprehensive data map. Sounds like an ideal world, doesn't it? Let's just assume, okay? So next step is to actually determine sort of what risk factors are involved in this contract. And given you've only got sort of 42 days, this is Chatham House rules, how many of your organisations have done this exercise? Okay. How many of your organisations know that you need to do it but just put their head in the sand and not really sort of gone through it? Okay. Okay, so, you know, as I said, you've got 42 days, so you need to focus on the high risk contracts. So what we sort of suggest is really doing a sort of a RAG analysis, red, amber, green. And so in terms of, you know, there's many factors of how you sort of determine how these would fit into different categories. So the red ones are the high risk or complex one. So these will require sort of bespoke sort of negotiation, full contract reviews. So these are like big, large IT procurement, strategic sort of outsourcing contracts. So the medium sort of contracts, they're unlikely to have sort of the high risk factors, but they may have profiling or processing of sensitive personal data. So they're still of significant risk. There may be sort of transfers outside the EEA, which increases the risk. So in terms of amber contracts, they require sort of more limited contract review and limited negotiation as opposed to the full-blown red contract. Then in terms of the green contracts, so these are the contracts where the supplier holds very little personal data, perhaps there's only contact details of your employees. So, you know, in most businesses, you know, a lot of the contracts will be green, you know, very low risk. Lots of businesses will have a lot of low risk contracts, a bit more amber contract, and a very few high risk contracts. There are, of course, risks with going through this approach, and we'll talk about this, you know, in terms of categorizing, but we are where we are, so it's better than just saying, I'm not going to do anything. At this stage, let's be realistic, you should probably only try to focus on the red ones, and if you get through them, focus on the amber ones. So in terms of sort of adopting sort of the green contracts approach, i.e. categorizing into red, amber, green, you know, what are the risks? And so some of the sort of risks are set out in this slide. It's not a comprehensive list of all the factors, but it just gives some general things. So, you know, one of the risks is the counterparty may not sign up. So the counterparties, as this gentleman said, will receive multiple requests to change, or particularly for a service provider, from all their customers to basically change their contracts. So you want to make sure this is as painless as possible. And what we recommend to clients is have some kind of click wrap approach, you know, so they don't have a wet signature, but some kind of process where the suppliers can actually easily hopefully accept. And I think the other thing that we found in experience is that if the contracts are, you know, they obviously have to be GDPR compliant, but they need to be straightforward, as uncontentious as possible. So it's not all about belts and braces, you know, all the wish list of stuff and put in the kitchen sink. As I said, I'm sure I've seen data protection. We act for customers and suppliers. When acting for suppliers, I've seen customers one which could go on for 25, 30 pages, I kid you not, you know. So you need to just focus on the key one because you want to try to get this concluded. So if you have things which are uncontroversial, i.e. the things which map the GDPR, you know, if the supplier is saying we can't accept that, you really need to think about, do you really want to be contracting with the supplier? This is the law. Why can't they comply with the law? So, you know, just try to make it as straightforward as possible. The other risk is, you know, explain this situation is effectively some people think, oh, we'll send out this variation or amendment and so forth, and we'll say, well, if you don't sort of return it, or if we don't hear anything from it, you deem to be accepted. Unfortunately, under English law, that doesn't work. So to sort of mitigate that effect, you actually, rather than just sending these addendums or data processing agreements willy-nilly or whatever, you need to actually present it in a way saying why you're doing it. You know, what is the reason why you're doing it? And you effectively, if it's true, what you need to say is, you know, you're not introducing any new provisions or trying to improve your contractual position. So say, for example, you know, the contractual provision that you currently got is the service provider's liability under data protection law is capped at, you know, 150% or 200% or, you know, X million pounds. So if you keep that status quo, you can say we're not changing the risk profile, but obviously if you're asking for unlimited liability, you can't say that. So you need to think about whether you're maintaining the status quo or if you're trying to improve your position. Even if you don't actually get a response from the third-party service provider, you need to have an audit trail of actually what agreements you've sent out, who you sent it out to, what follow-ups you've done, and all that, to show to the regulator that you've done all that's possible. So there's no point just saying, oh yeah, we sent out a raft of contracts, don't really know who to, we followed up some, but other ones we didn't. You know, you need to track everything you've done. You need an audit trail because, you know, ultimately if there's a breach, you will be responsible for not having a clause with GDPR compliant clause, but you can say, look, we did all that was possible. We tracked it, we had these clauses, spent lots of money with our external lawyers, we set these things up and we just, you know, we just didn't get a response, but we tried. So you need to make sure you've got that. The other risk is, you know, adequate contractual consideration. So under English law, under a contract, you need to have some kind of consideration. So it doesn't need to be monetary, but some kind of consideration for it to be binding. So technical legal point. So that's why sometimes these agreements are drafted as deeds. So that needs sort of specific signing provisions, and you know, electronically you can't sign deeds, so a bit of a problem. So one solution to do this is to include some kind of nominal consideration, say for £1 or something like that, which is deemed to have been received. Whether that's, you know, is actual consideration, hasn't been tested, but you know, it's better than nothing. You could also sort of include sort of a mutual benefit, sort of a mutual set-off clause, saying that each party sort of enters into this agreement for the mutual benefit of the other, and you know, so that could be sort of the consideration. So in terms of the red and amber contracts. So that's the approach for green contracts, you know, fairly sort of, you know, light touch approach. For red and amber contracts, you know, what are some of the key issues you need to think about in these high risk contracts? So limitation and indemnity issues. So customer's perspective is that you want to have uncapped indemnity, uncapped liability. Service provider is going to try to limit their liability. So what you need to try to do is try to get a compromise. Ideally, you would want the highest sort of highest cap there. Often with limitation and indemnities of liability, it just becomes a bit of a theoretical exercise. So example is you may be a large organisation, you're dealing with a service provider who is fairly small SME, but they are processing a lot of your personal data. It could be sensitive personal data. But that SME, you know, they're resisting unlimited liability. You go, oh, well, we want 10 million, 20 million, whatever. But that business may only be able to sustain a claim of maybe 1 million or 2 million. So it doesn't matter what the liability is about that 1 or 2 million. So you need to actually do the due diligence on the service provider and see what their actual ability is to sustain these, you know, a claim. Because theoretically, yeah, you may have a really huge liability cap, but you know, that doesn't do any good if basically you put them out of business. So you need to think about it in a practical context. You need the right to audit and inspect both the service provider and the sub-processor. It needs to be at no cost. The supplier's perspective here, they'll try to push back on this. And you know, they may offer independent third-party audits, which you may think that's okay, and they may say we don't want to have all the costs, we want to share some of the costs. So again, a point of negotiation. So another key issue is about data breaches. So you know, under the GDPR, you as a data controller has to identify the regulator within 72 hours of becoming aware of the breach. So that's a requirement by law. So you may want to push that onto the service provider, but the service provider will try to resist this. So what you need to do is try to avoid language that the service provider says we'll respond to you as soon as practical or reasonable, because that may mean that you're in breach of your obligation to report to the regulator. You need to make sure, even though it's not 72 hours, it's less. If it's 72 hours, that's going to be a bit difficult, so it needs to be clearly less than 72 hours. Engaging sub-processors, another issue. You basically want a direct obligation on the processor to ensure that all the sub-processors personnel are trained and so forth, and approval in writing prior to engaging. The service providers will resist this and say, oh, hang on, we can't get you to, you know, we can't approve all, we can't appoint sub-processors and get approval for all that. That's unpractical. So what you could do is sort of decide on a categorization of subcontractors. So you can say for key subcontractors, you know, they need to get your prior approval. For sort of non-key subcontractors, they don't, but you still need to notify them. Then the question becomes, how do you define a key subcontractor and so forth. Yes?
It's 72 hours from when you identify the breach as opposed to 72 hours from when it occurs, is that right?
When you become aware of the
You become
breach.
aware of
Yeah.
it,
Hello?
Is there a role for pushing the requirement for cyber risk insurance onto your supply chain? So I'm just trying to think about how you get over the caps, right? But if you make sure that they've got insurance that they can pay you if something happens.
Yeah. Yeah, there's currently debate of whether fines are actually insurable or not. I don't know if there's any cyber insurance that, whether actually you can get insurance for fines.
Payouts have been made for fines.
Yeah.
Not in the UK as far as I know.
Yeah.
Does that mean that we should be getting like general set professional indemnity cover on data controllers in particular companies?
Well, that's what I was thinking.
Yeah, well, it's only if but as I said, most insurance policies don't cover fines, so you won't, that won't cover, but you may get, you may get other things covered through that.
So would the liability be on the data control or the company both?
Data
In
control.
terms of the fines?
It could be both, it depends on where the regulated things, I mean, to a certain extent, it's sort of, they'll probably I suspect they'll probably come against both, I think.
I would have thought
So, in some of the practical challenges we've actually seen in terms of negotiating these processing contracts, so the businesses themselves may not understand their data flows or what the data is, where it's being transferred. They may not have adequate IT security or legal expertise. But what we're seeing is that this will, if you think of entering into a big, large outsourcing or an IT contract now, this will add time to it, so you need to factor that into the deal timetable. And sort of the process, as I said, due diligence, data mapping, identify the contract type and risk factors, and engage with the counterparty and update. I know that seems very simplistic, easy for me to say that, but that is the process that needs to be done. So in terms of future sort of supply contracts, so in terms of going forward, make sure you've developed sort of precedent contractual clauses. So, even though you're thinking, I'm not going to get this done by May 25, okay, fine, but you still need to get it done at some stage. So you might as well start it now. The gentleman talked about data protection impact assessments, talked about data privacy and design and default. Think about principle of data minimization, i.e. if you're engaging a service provider, maybe have an obligation on them to actually have an obligation to minimize the data. Think about, do they really need to do profiling, automated decision making, and then think about any other risk factor. I know that's a catch-all. For example, transfers outside the EEA. Lots of people haven't really thought about sensitive data and so forth. So that's it. I know it's a bit of a whistle-stop tour. How much time have we got?
We've got 15 minutes for questions, if anyone's got any questions to ask.
Hey.
Out of curiosity, is there any guidance in law on the criteria for who a data controller is, in terms of, does a data controller need to be a named individual? Does it need to be a particular seniority in a company?
Sorry, are you talking about data protection officer or data controller?
Data controller.
Okay, no, data controller is always an organisation. It's a corporate entity.
Okay, it's an entity as opposed to an individual. It's an entity.
An individual can't be a data controller. No, it has to be a corporate entity, unless of course you're a sole trader. So yeah.
Different question. I've got my development hat on today.
Yeah.
I use a lot of subcontractors to do development in the Indian subcontinent and some in Singapore.
Yeah.
They don't actually transfer the data, but they have remote access to it.
That's counted as a transfer. Sorry, I've had this question before.
My assumption is that it counts as a transfer. There's no get out.
Yeah.
No, okay.
Yeah. So even though physically there's no, they'll argue there's no, the fact that they're actually accessing the data outside the EA, that's deemed to be a transfer. Okay. Sorry.
Just looking for a simple way.
I've got a question to ask. You mentioned a few times EEA, not EU.
Yeah.
In practical terms, GDPR concerns EU citizens. Does EU treat EEA citizens as EU citizens in terms of GDPR? For instance, if an American company has got a contract with a Norwegian company, and Norway is part of EEA, not EU.
Yeah.
So Norwegian citizens, they're going to be treated as EU citizens, or?
I think that's a bit of a misconception. Forget about this citizen stuff. Yeah, that's a misconception. So just think about the EEA, EEA businesses and EEA data subjects. It doesn't have to be a citizen. So you could be a US citizen who's actually coming here, visiting, or even permanent residency. You'll still have rights under the GDPR. So it's not about citizenship.
So how does the new Cloud Act in the States affect things?
Sorry, I haven't. I know that I haven't sort of.
It was only 2 days ago. So.
Yeah. Sorry, I'm trying to deal with the fires and getting this stuff done. But yeah, do you want to? Yeah, I know that's about access by
federal and other law enforcement officers.
Yeah.
Offices around the world.
Yeah. I mean, I guess it's similar to the Patriot Act to a certain extent. So the GDPR does have carve-outs or derogations to say that, you know, if you as a service provider are required by law to actually give it to a government, then you're not in breach of GDPR.
Okay.
Yeah, I mean, I don't think that really changes it. I think that cloud thing is more about putting more controls or less controls about.
It's mostly about getting Microsoft versus DOJ. That's mostly what it is.
Are there any exemptions from GDPR? Any companies, any government entities, or they don't have to comply with GDPR?
Yeah, if you don't process personal data.
If they do, right?
Yeah, no. No.
So security services, they have to comply with GDPR?
In terms of the government?
Yeah.
Yeah. They'll have different sort of regulations as well that may override the GDPR. Yeah.
Sorry, what about people without an immigration status?
As I said, it doesn't matter about your immigration status.
About it was not applied to people without an immigration status.
No.
I think it's in the data protection bill somewhere.
Okay.
There was a discussion in committee that someone objected to because the government was seeking to restrict the data subject right to have data corrected if it related to immigration.
Which was interesting. It is an interesting point, but I think this is one of the issues here with data protection. People sort of get, I'm not saying you are, but people get interested in these sort of very sort of specific new, but in the overall impact of a business organisation, that doesn't really matter. You know, let's look at the big picture here. You know, you could get into a lot of debate about, you know, the Daily Mail about, well, you're a small SME, you know, do I need to do DPIs, all this kind. Just focus on the sort of commercial reality. Otherwise, you know, you're not going to get there.
Sam?
Yeah.
From a service provider perspective, we've got a range of different solutions and services that we provide. Some of them are very clear. We've got bespoke software and we've got hosting arrangements that we provide to them, and we're clearly a processor. There's also a range of situations where we either provide software only, our client hosts the data and operates it, and equally where we may just supply some shrink wrap software from a third party. Is that provision of software as opposed to the managing of the personal data, does that make you a processor?
No, because if you're just providing software, if you've got a piece of software product, and if you've got no access to personal data, so you develop a piece of software, traditional software, here, you deploy it, you install it, that's it, you know, then no. But interesting, if you're providing support and maintenance to that software, you will have contact details of the people, so you will be a processor in that respect when you're providing help desk.
You could be supporting and maintaining on a test environment which isn't live and therefore doesn't have real data.
But technically you'll still have the personal data of the person contacting you.
Of the person making the incident reports?
Yeah.
Okay, so the incident report. Okay, but that in a way is almost similar to our obligation as a standard organisation. We hold personal data of our employees, etc. I'm thinking more.
Yeah, but in that situation, you'll still be a processor in terms of third-party processor. Okay.
Thank you.
Yeah.
Is there a way you can do like legal e-discovery compliance so you can detect breaches?
Sorry, is there
an e-discovery tool that lawyers, legal people like yourself can utilise so that you can set up for a client to be able to detect breaches?
Detect breaches or non-compliance?
Both.
Well, we can't detect breaches because breaches are a question of fact, whether it's happened or not.
Okay, before that then.
We've got tools and stuff. We can sort of AI tools and algorithms and review tools that we can review contracts and say these contracts aren't GDPR. And we've been doing this for clients, particular large banks and stuff.
Would you be able to program that to go through a database, say?
Sorry?
Would you be able to program that to go through a database?
I don't know the tech. I'm going to say the opposite to you. I'm not a techie. I don't know how they do it. We've just got a black box solution. They do it. We get the results. What's your
No,
thing?
I've got a fintech background as well as an SME background.
Yeah.
I'm at 5 years HP Big Data Group.
Yeah.
Prior to obviously where I am now, and I'm keen to go into fintech. So I'm looking at some kind of e-discovery element where we could proactively look inside the database to see what's compliant, what's not compliant, and then potentially look at professional services opportunities to make a client compliant. So look, you're potentially in breach 4% X, Y, Z. You could get a double bubble fine, data controller, and your company. So your 4% is, guess what, 8%. We've done this X, Y, Z discovery search.
Yeah.
You need to do this.
Yeah.
We have half a million quid, please. So, do you know what I mean?
Yeah.
The challenge with GDPR compared to something, the challenge with that compared to something like PCI DSS,
That's what I was thinking.
it's pretty binary if you've got a primary account number. It's
Yeah.
16 digits and it's concatenated with hyphens and it's quite easy. The challenge, I'm sure you guys have heard of you, but the challenge with GDPR is the context of what personal information could be, just the volume of false positives, unless you're using something like a Bayesian AI algorithm that you're preloading with lots of information to tell it what is good from bad, but traditionally discovery wouldn't help you. Someone will just turn it off after 5 minutes because you'll be telling them it's personal and you'll go through this long rigmarole of identifying that actually it's not, or these are the controls that are in place.
But what
We've thought about that.
Yeah, but what we
could use Bayesian for program to search for certain phrases.
You could do a supervised MI algorithm that would look, but you weren't doing it based on signatures. So that's the challenge with traditional e-discovery. You have to know the signature of it.
Yeah.
So if you can load terabytes, this is what it would need, of information and tell it this is personal information, that isn't personal information. And we've done some analysis in this, and there are companies that are doing it, I'm sure you know, but to what degree of efficacy, I'm not sure.
Well, what we're doing is we can do contract reviews.
Yeah,
but I mean, because that's relatively easy in terms of look for this sort of formula wording or stuff. This is what the GDPR required. Program this, look at the formula wording and then variations, and then if it doesn't have it, we can say, well, this contract doesn't have this provision or that. So from a contractual lead, we can do that, and we have.
What's to stop it? I mean, if a company goes and sets up a BVI trust or in Mauritius or wherever, and it moves all the key officers overseas or wherever, so nothing's in the EU, would that give them any kind of defence in this or not?
Well, no, because they'll still be if they're still processing personal data of data subjects in the EU. So US company or Chinese companies, they may have no offices in the US, in the EEA, but they're processing personal data of EEA data subject. They're still caught. There's a GDPR that's got extraterritorial reach.
So Cambridge Analytica set a trust in Panama tomorrow.
Yeah.
It's not going to help at all.
Well, it could help you if they didn't have any assets in terms of the enforcement. I.e., they'll still be technically fine, but if they haven't got any sort of assets here, they'll have to have some kind of mutual recognition enforcement order against the countries. So that's the second step.
Because with the trust, you can actually make sure the assets there belong to the trust, not the people who work for it, can't you?
Yeah, but I think we're sort of going in a tangent in terms of, the whole, it's about protecting personal data and managing risk. It's not about excluding liability for trying to avoid the law.
No,
I mean...
I understand that. This is coming from a gamekeeper perspective.
What person?
Gamekeeper perspective.
Yeah, okay.
About how we can use the law from a pro-services compliance perspective to get people to be compliant and detect things and prevent problems and prevent criminal activity.
Yeah.
So that's the question.
Any other questions? I'll be around just before lunchtime if you want to.
Please join me to thank Sam for the presentation.